Welcome to the June 2024 edition of This Month in Payroll. I'm Claire Soccio, a partner in PwC's Payroll Advisory and Operations practice. This month we will focus on the Fair Work Commission's annual wage review and two significant decisions relating to long service leave and compliance obligations for holding companies and master franchisors. This month began with the Fair Work Commission announcing its annual wage review, which includes two key aspects. The National Minimum Wage Order, which sets the minimum rate of pay for employees not covered by an award or enterprise agreement, and the Modern Award minimum wages, which are estimated to impact a quarter of the workforce, the majority of whom are female and part-time or casual employees. In reaching its wage review decision, the Commission primarily focused on cost of living pressures, but balanced those against inflation being considerably lower than it was at this time last year, and stagnant labour productivity. The Commission also considered the backdrop of last year's sizable 5.75% minimum wage increase and the benefits soon to be realised by workers from Stage 3 tax cuts and other budget cost of living measures. Ultimately, the Commission decided on a 3.75% increase to both the national minimum wage and all Modern Award minimum wage rates. This change is effective from the first full pay period on or after 1 July 2024. In practice, this increases the national minimum wage to $915.90 for a 38-hour working week, up from $882.80, or to $24.10 per hour, up from $23.23. Employers should consider the impact of this decision, including updating rates of pay in system and documenting all associated testing and approvals, assessing any consequential impacts for annualised salary arrangements, noting that the buffer between minimum award entitlements and the salary may now be reduced by this 3.75% increase, and reviewing the base rates of pay in enterprise agreements to make sure they are equivalent to or higher than the corresponding rate under the relevant modern award. And while reviewing these arrangements, employers should also remember to consider any impact of the superannuation guarantee contribution rate change, which increases to 11.5%, also effective 1 July. When delivering this decision, the Commission also restated its commitment to the timely resolution of gender undervaluation issues. This is a topic we've been following with interest over recent editions, and involves a program to consider the classification and minimum wage rates within awards relevant to certain female-dominant sectors. The Commission has now prioritised the review of 5 modern awards across the next year, including those applicable to early childhood education and care workers, disability, social and community care workers, and certain health sector professionals. A similar review of other awards and sectors will then follow in later years. Now to a very interesting decision regarding continuous service for Queensland long service leave entitlements. The full bench of the Queensland Industrial Relations Commission recently delivered a judgment that awarded long service leave entitlements to a worker who had spent a mere 18 days working in Queensland. We're going to look at the background to this case of Fox versus Infosys Technologies Limited to understand how the full bench reached this decision. The case considered the continuous service of a former employee of Infosys, which is an Indian-headquartered tech company. Mr. Narendra Gade began his employment with Infosys in India on the 5th of March 2012. He worked there for a little over 6 years before being relocated to Melbourne in June 2018. Mr. Gade continued working for Infosys in Melbourne for nearly 4 years, from June 2018 until March 2022, which is also when he reached 10 years of continuous service with Infosys. In early 2022, Mr. Gade requested a relocation to Brisbane. Infosys agreed, and just prior to that relocation, while still in Melbourne, Mr. Gade resigned. He worked his notice period partly in Melbourne and partly in Brisbane, ultimately ending his employment on the 14th of April 2022, 18 days after relocating to Queensland. Now, the Industrial Relations Act 2016 Queensland requires an employee to have completed 10 years of continuous service to be eligible for long service leave. Section 93 of that IR Act defines continuous service as being, quote, with the same employer, whether wholly in the state or partly in and partly outside the state, end quote. Mr. Gade relied on Section 93 and argued that he was entitled to long service leave because his service was partly in and partly outside the state, with those 18 days served in Queensland. Infosys, in turn, argued that the relevant clauses should be interpreted so as to require a substantial connection between Mr. Gade's service and the state of Queensland. They contended that his minimal 18 days of service in Queensland was incidental to his original employment in India. The Commission dismissed this argument, distinguishing the continuous service requirements for Queensland from those for New South Wales and Victoria. Those states don't have a provision like the Queensland one that allows for service partly in and partly outside the state. New South Wales and Victoria have therefore adopted a requirement for a substantial connection when assessing an entitlement to long service leave. This has been upheld in cases that we have discussed previously, including the 2022 New South Wales decision of Wipro and the 2021 Victorian decision of Infosys Technologies. Yep, that's the same Infosys, but a different matter. Both of these decisions required a substantial connection between the employee's continuous service and the state in which they were claiming long service leave, and ultimately excluded periods of service that was performed outside the states of New South Wales and Victoria. This position for those states was distinguished from the Queensland legislation, which by contrast specifically requires the inclusion of service performed partly in another state or jurisdiction. So returning now to Mr. Gade's claim, the Commission concluded that the key question is whether it can be established that there is service within the state of Queensland. Once that is established, the entire duration of qualifying continuous service must consider service performed outside Queensland, whether that's interstate or internationally. Mr. Gade's employment contract, while executed in India, included terms that provided for him to serve Infosys in other jurisdictions, and he was therefore taken to have performed service in both Victoria and Queensland. Another interesting side note is that Mr. Gade was eligible to receive payment of a similar nature to long service entitlements in India, and the Commission concluded that there was no legal basis to allow Infosys to offset that payment against the Queensland long service leave entitlement. So Mr. Gade received both entitlements in full in both India and Queensland. So what are the key lessons? Employers need to take great care to navigate the nuances between the long service leave obligations in different states. This is especially the case where employees are moving between jurisdictions. When it comes to Queensland, there is no substantial connection requirement as exists for other states. So particular care should be taken for employees performing services partly in Queensland, even if those are of a short duration. And lastly, but no less importantly, this month the Fair Work Ombudsman secured penalties of $1.44 million, the third highest on record, against a master franchisor for its systemic failure to ensure compliance within its franchise network, including in respect of underpayments and record-keeping contraventions. This is the first litigation of its kind since the Protecting Vulnerable Workers amendments were made to the Fair Work Act in 2017, expanding the accessorial liability provisions to franchisors with a significant degree of influence or control. Similar liabilities apply to holding companies for their subsidiaries within the corporate group structure. While the master franchisor in this case, Coffee Chain 85 Degrees, did not itself underpay the workers, the federal court concluded that it should reasonably have known, and from April 2019 it did in fact know, that its franchisees would commit contraventions, and it did not take reasonable steps to prevent them occurring. In setting the very substantial overall penalty, Justice Bromwich noted the franchisor's history of non-compliance and the need for general deterrence, suggesting a high risk of similar contraventions in the food retail sector. He also saw the need to impose a penalty at a level that would deter other would-be contraveners and especially other franchisors from turning a blind eye to compliance. So how can holding companies and franchisors protect themselves? This decision is a reminder to check that necessary systems for compliance, record keeping, and payslip reporting are in place across all entities within a group structure. Administrative obligations, such as record keeping and payslip compliance, are taken seriously by the courts and the regulator and should be considered equally as important as other obligations to pay or accrue employee entitlements. If found responsible for a contravention, courts may order the responsible holding company or franchisor to pay any underpayments, including wages, superannuation, and leave, as well as penalties. Reasonable steps must be taken to ensure compliance of subsidiaries and franchisees with all workplace obligations. Steps that may be considered reasonable are likely to include elements such as resources, education, processes and controls, arrangements to address questions or complaints, and formal obligations that require subsidiaries or franchisees to comply with workplace obligations. And that's it for our June edition of This Month in Payroll. If you would like to revisit any of our prior updates, they're available on our website at pwc.com.au/payroll. And if you have any questions or need for support, please reach out to myself or your usual PwC contact. Until next time, have a great month in payroll.